Okay, we're on the record now in People versus Brandon O'Neill. And this is case number 235146. The record should reflect Mr. O'Neill is present today in jail. We have Mr. Thompson here for purposes of arraignment by Zoom video, and Mr. McFalda on behalf of probation. And then 1 second, I've got the prosecutor in here as well. Okay, Mr. O'Neill, you're before the court today for arraignment on alleged violation of your probation. Have you been made aware of what the alleged violation is?
No, sir.
Okay, so it's alleged that you committed 2 violations. One is a technical violation, and that is violation of special condition 4.25, in that you failed to report a change of residence to your probation agent within 24 hours.
Yeah.
And you are alleged to have committed a non-technical probation violation. And that is condition 3, that you are to report to your probation as ordered, and that you failed to report on or about October 26th of 2023. Do you understand the alleged violations?
Yes, sir.
Okay. A couple of things that I need to go through with you with regard to your rights. Number 1, you do have the right to have a hearing as to whether or not you violated your probation as alleged. You also have the right to have an attorney present at any subsequent proceedings. If you can't afford an attorney, one would be appointed for you at public expense. As I indicated at the beginning of the hearing, Mr. Thompson is here for purposes of arraignment today. If you are found guilty of the non-technical probation violation, the maximum possible penalty that you could face would be that of your original charge, which is possession of methamphetamine. Do you understand all those things that I've stated to you?
Yes, sir.
Okay. Mr. Thompson, have you had a chance to speak with Mr. O'Neill prior to the hearing today? You're muted, Mr. Thompson.
No, Your Honor, I'm sorry. I came to the courthouse today. I didn't realize this was a virtual hearing.
Okay. All right. Do you want to have a chance to speak with Mr. O'Neill in a breakout room?
Yes, please.
Okay, so Mr. O'Neill, I'm going to put you in a breakout room with Mr. Thompson so that you can have a private conversation. Okay.
Okay. Okay.
Still there?
Thompson, were you able to have a chance to speak with Mr. O'Neill?
Yes, I'm sorry, I got little confused when the meeting ended, but yes, we talked.
Okay. Okay, how does Mr. O'Neill want to plead to the alleged violations today?
I believe he would plead guilty to failure to report. I had previously heard from the probation officer that the recommendation to your honor would be a 30-day jail sentence.
Okay, Mr. McFeldin, want to address that?
Judge, this is like the second time in the last few months that we've been in the same situation. Mr. O'Neill shown is not going to be a good candidate for further probation. I would ask. This is Mr. Haven's case, but I've talked to him a little bit. He's off today. I would recommend 30 days jail, credit for one served, and then discharge him from probation unsuccessfully.
Okay, Mr. O'Neill, were you able to hear that?
Yes, sir, I was.
Okay, is that how you wanted to go forward today?
Yes, sir.
Did you need any more time to speak with a lawyer before you make that decision?
No, sir, I appreciate it though.
Okay, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can lower your hand. Mr. O'Neill, you understand that you do have the right to have a hearing as to whether or not you violated your probation?
Yes, sir.
And you understand that by pleading guilty, you're going to be giving up that right?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we've said here on the record today?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty to this violation because you are in fact guilty?
Yes, sir.
Okay, back in October of this year, October of 2023, were you on probation out of Crawford County?
Yes, sir.
And were you aware that one of the conditions of your probation was that you were to report to your probation officer as ordered?
Yes, sir.
And did you fail to do that on or about October 26th of 2023?
Yes, sir, correct.
Okay, the court finds that the plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that Mr. O'Neill did violate his probation as alleged in the non-technical violation. The court will accept the guilty plea. Other than what you've already stated, Mr. McFalda, is there anything that you wanted to state with regard to sentencing?
No, Judge.
Mr. O'Neill, was there anything further that you wanted to state regarding sentencing in this case?
I've been in here since Friday night. Would I get the Friday up to now credited?
Mr. McFalda, is there any reason why you wouldn't get credit for the time that he's been lodged on this warrant?
No, Judge, I would agree with that. So Friday night,
Okay,
I guess it would be 6 days credit.
okay. Mr. Thompson, was there anything that you wanted to say on behalf of Mr. O'Neill today?
Your honor, we're urging the court to accept the recommendation. I think it's appropriate given all the circumstances. Thank you.
Okay, I did have a chance to review the register of actions, so familiar with the arc of the case here and the issues that you've had while on probation, Mr. O'Neill. And I think given Mr. McFalda's statements here on the record today, I think it's a reasonable way to proceed. I think it provides a degree of punishment for your failures while on probation. And I also agree that at this point, it would be appropriate to simply discharge you after serving what I consider to be a reasonable sentence given the violation. So the court is going to follow the recommendation. The court will sentence you to 30 days in the Crawford County Jail. You do have credit for 6 days served. The court is going to discharge you unsuccessfully from probation and preserve any outstanding fines and costs. You do have the ability to appeal this sentence. You will be provided with some paperwork, Mr. O'Neill, that explains to you what your appellate rights are, as well as how to request a lawyer to help you with an appeal if you wanted to do that.
Okay, sir.
Mr. McFalda, anything further that we need to address today?
No, that's it, Judge.
Mr. O'Neill, did you have any questions about the sentence?
No, sir.
Okay. Mr.
Judge, I
Thompson,
will
anything?
send those orders up for you.
Okay, great, thank you. If you can just email those, Sarah, and I can sign them. Okay,
Will do. Thank you.
thank you. Mr. Thompson, anything further from your side?
Nothing further. Thank you, Your Honor.
Okay, thank you. That concludes this hearing, and all parties are free to disconnect this time.
All right. Thank you, Your Honor.
Your Honor.
Yes.
So I didn't get a chance to talk to Mr. Galarno primarily because he's not in Kilkaskia, he's in Wexford. I don't know if you can give me like a short breakout room and I can just explain to him what the situation is.
Yep, I can definitely do that, and I will do that right now. Okay, I'm opening up the breakout room right now.
Okay, thanks, Your Honor.
Yeah, apparently I'm done. They hung up on me.
All right, Mr. Galarno, are you able to hear me okay?
Oh, hey, Mr. Judge Joe Church. I'm sorry, Seeger hung up on me.
Mr. Seeger, did you need more time to talk to Mr. Galarno?
Mr. Galarno doesn't want to talk to me, and that's fine. He's been assigned alternate counsel through another instance. he now has a pending file for an unrelated charge for which the current violation for his probation violation is currently pending. That's the sum and substance for the violation hearing today. I asked him if he wanted an attorney. He said yes. I will assign him the same attorney that he's currently assigned for his master file together with a new charge that's pending. So that would be Mr. Horowitz.
Okay, Mr. Galarno, is that correct?
That's correct, sir.
Okay, all right. So Mr. Galarno, I just want to make sure that you understand all of your rights with regard to the alleged violation. First of all, have you been made aware of what the alleged probation violation is?
Not really. Are we on the record here?
Yes, we are.
Okay. I just wanted to make sure, because as far as I know, the probation was extended without any hearing as well. Seeger keeps getting involved in my cases for some reason when I've fired him as my defense attorney for perjury of the court. And I'm trying to figure out why I keep having him involved with anything that I have to do. He's lied, he set me up, he put me in this position as I'm in right now. And I gotta keep dealing with him for some reason. Nobody knew it.
The court tries to make, well, it doesn't try. We have an obligation to make sure that you have an attorney present for any court hearings. And so today, Mr. Seeger happened to be the attorney that was available. So that's why he was appearing today. And if you don't want him to be your attorney, that's fine. We're going to have a different attorney assigned to you. So do you understand what the alleged violation is?
No, sir.
Okay, it's alleged that you violated your probation by being in possession of a firearm on or about December 21st of 2023. That's the allegation. Do you understand what the allegation is?
Allegation is understood, Your Honor. Probation officer never came to do a wellness check on me. So any kind of, it was a warrantless check. Everything was invalid. So I don't even know why I'm still sitting here.
Well, today we're just here for arraignment, which means I have to make sure you understand your rights, and it sounds like you're going to want to plead not guilty. Is that correct?
Correct.
Okay, so you have the right to have a hearing, and at that hearing you can raise whatever arguments you believe are valid arguments for why you should not be found guilty, okay?
Yes, sir.
So the court's going to enter a not guilty plea on your behalf with regard to the alleged violation, and the court will set this for a hearing. In terms of bond pending that hearing, Ms. Wagner, do you have any recommendations for the court?
I do, Your Honor, just briefly. Mr. Galarno has 7 felonies with prior felonies to include receiving and concealing stolen property, UDAA, multiple counts of felonious assault.
Well, this is over 20 years old.
Okay, that he's been to
13,
prison
I'm
on.
50 years
Please
old.
let me speak, Mr. Galarno.
Mr. Galarno, we're not here to argue. Your record is what it is, okay? Ms. Wagner is just making me aware of what your record is. I'm going to give you a chance to address me on bond in a minute.
My apologies.
Go ahead, Ms. Wagner.
And he is on bond for criminal charges from back in, I believe, 2020 maybe, or 2021 for involving firearms, and that is scheduled for jury trial in January. So he's on bond for those criminal charges. He's on probation, bond. He's been charged with felon in possession of firearm and felony firearm at this time, with possible more criminal charges coming forth, according to the prosecutor. Bond was originally set in this case on the new criminal at $75,000 cash or surety, which I think was appropriate. It was reduced at his arraignment to $50,000 cash. He did post it, but I do think the $75,000 cash is an appropriate bond for this defendant. Thank you.
Thank you. Mr. Galarno, what would you like to say regarding the amount of bond?
Well, I don't know what else to say beyond that. I'm on disability, so there's not much I can afford. I do have trial at the end of January. And I'd love to spend whatever time I can with my kids before I have to get to the trial date. So to see whatever happens. It's entirely up to you, sir. You know, all I can do is hope for the best.
Your Honor, the only other thing that I would add on behalf of Mr. Galarno is that Mr. Galarno has been required as part of the other case that's part and parcel of the probation violation. He's already required to post a bond, and so it's somewhat double dipping in as much as he's already required to post a bond based on the conduct that's alleged in the probation violation. And so if he's able to post that bond, if the court was willing to give him a PR bond, which he is entitled to a presumption of innocence, he does have a trial coming up in January for which Mr. Horowitz is his attorney of record. He was subsequently appointed to Mr. Horowitz for this new attendant charge, which he denies is untrue. And then he will also be appointed to Mr. Horowitz relative to his request for a attorney in the probation file. But because he's already posted, according to Ms. Wagner, his bond in the district court, there then it seems as though we're somewhat double dipping on him because he's already posted the bond for which he's being held.
Okay. All right. I'm familiar with Mr. Galarno's pending case. I'm also familiar with his record based on a prior jury trial that we had on the charges in this case. The court has some concerns regarding public safety with the allegations involving the possession of firearms and the allegations arising from additional criminal charges, which are alleged while Mr. Galarno was on probation and on bond. So he continues to be charged with additional crimes while he's currently under supervision and subject to bond conditions. So the court has serious concerns for public safety if Mr. Galarno is released without a significant bond. So the court finds that the amount of bond is imposed by the district court would be an appropriate amount. So the court is going to set bond at $50,000 cash or surety. And then again, the court will set this for a hearing at its next available date. The court will order that Mr. Horowitz be appointed to represent Mr. Galarno on this file. And we'll go forward as scheduled then. Ms. Wagner, anything further that we need to address here today on the record from your side?
No, Your Honor. Thank you.
Mr. Galarno, do you have any questions about how we're going to go forward?
Not at this moment, sir.
Okay. All right. Thank you. That's all for this hearing today. And Ms. Matley, that I will send you the bond paperwork by email. And all parties are free to